Hello, everyone. Thank you for attending our 2023 employment law update. What we'll be going through today is the changes that came out of last year. We'll also be talking about some trends and some recommendations that we have for you going forward. As always, we had a very busy year in 2023 for California employment law. And there was a lot of cases, a lot of laws. And what I've done in this presentation is selected those that I found to be the most applicable to our client base. So there may be some updates that apply to your particular business or industry that I'm not covering here today, but we only have an hour. So we're going to do our best to cover as much as possible in an easy to understand way. Feel free to ask questions as we go along. For those of you who don't know me, my name is Jamie Bossuat, and I'm an employment law attorney at Kroloff. And I provide for my clients policy development, employee handbooks, advice and counsel as you go through the process with your employees and encounter difficulties. And then I also litigate cases all the way through jury trials. So we are going to jump right in here. Oops, if I could get it to move forward. There we go, with wage and hour. As with the last several years, this has been a very prolific area of the law and employment law. When I started many years ago now, the focus was on wage and hour, but we saw a lot more harassment and discrimination cases than I think we're seeing today. Today, we're just seeing a lot of wage and hour cases and a lot of wage and hour claims, and that's attributable to the amount of detail that the courts are now expecting out of employers. And we will see that as we move forward in today's presentation. I'll just start out with some basics. The minimum wage increased this year again to $15.50 on January 1st. That then bumps up your minimum salaries for someone to be exempt from overtime to $64,480. So if you have employees that are on the cusp of this salary and you have them classified as exempt employees, you need to evaluate whether or not they need to have a salary increase or whether you want to make them non-exempt employees. And each year, our minimum wage is now tied to some other factors. So it will continue to go up each year. So that's something, if your person is close to this number now, they might not meet it next year. And so you can do some planning ahead of time, knowing that that minimum wage is going to go up on January 1st again. There was an initiative on the ballot to raise this to $18 an hour, and that did not pass. But we might see another one next year. The mileage reimbursement rate from the IRS has gone up to 65.5 cents per mile. That is lagging behind some contract reimbursement rates. And I get the question often from clients, do we have to pay the IRS mileage reimbursement rate? The IRS mileage reimbursement rate is widely accepted as being a good metric for what personal mileage costs an employee who drives their personal vehicle. So I do have quite a few cases on my desk right now where that argument is being made, that the mileage rate being paid by the company, which was set by a contract, usually with a government agency, is not sufficient because the IRS mileage rate went up last year in July and now it's gone up again. And so this is actually the ceiling for what the IRS is willing to consider as non-taxable income or non-taxable earnings toward an employee's mileage. But there are arguments to be made that, and there are other calculations that are allowed that would allow you to set the mileage at a different rate. But in California, what we have to remember is that we're going to have to prove that the rate that we're paying is an adequate amount to completely compensate the employee for their use of their personal vehicle. So this happens to be an easy way to do that that's widely accepted. If you have employees driving unique types of cars or some other factors that are relevant, you could consider those, but you're going to have to be able to justify that amount. Moving on to some more standard timekeeping policies. And this is how I've got the presentation set up this year. I have the cases and the facts, and then we're going to talk about what the takeaway is for employers. And so also, I just got a question. Will the PowerPoint be sent out after the meeting? Yes, I will email the PowerPoint to everyone that registered for the webinar. So if your email was included with your registration, you will get a copy of the PowerPoint. If you want the PowerPoint to be sent to someone else that's not the registered email, please send me an email and I'll go ahead and send that to you. We're also going to put this webinar up on our website, so you can view it again later if you would like. So in this case, Camp versus Home Depot, the employee here challenged the employer's rounding policy. And in California for many years, we've had a well-established policy that employers could round their time card punches to the quarter hour. And a lot of employers do that. Some will round to 6 minutes, some 10, some 15, but that's by and large been accepted up until now. And the last year, or maybe the year before, I can't recall, we had a case that said that you can't round the employee's meal periods. Some of you may remember that. They have to get exactly 30 minutes minimum for their lunch period, and you can't round that. So if they happen to check back in a minute early, that could potentially give rise to a violation, depending on the circumstance. So we saw that with meal periods, and now this case is moving in that direction with your hourly punches to determine the amount of time worked. So this employer captured time to the minute with the time clock system, and then when it went through the payroll system, it was rounded to the quarter hour. They conducted a sampling and they looked at whether or not this was a neutral policy. And overall, the employees weren't shorted any time when we looked at a sampling of the time punches. And in fact, there were two plaintiffs in this case. One was actually overpaid, and the other was underpaid. And the underpaid employee was allowed to proceed, even though there was a neutral rounding policy. And the court said, because your time system actually captured this employee's time to the minute, and we can definitively say that this employee wasn't paid for every minute that they worked because of the rounding, then this employee gets to proceed with their case, and we'll see how much they are owed for that time. So the court disagreed that it was proper to round to the quarter hour if the time clock system was capturing to the minute. So this is something, a definite takeaway to go back, and a tip. Look at your systems. How are they rounding? How are you capturing time? The court didn't say rounding is prohibited, but the court did say that there are circumstances like this one in which it may not be proper. So if you have employees that aren't clocking in and aren't doing to the minute, maybe they're writing down on timesheets, or there's some other factors that make rounding the best way of capturing those employees' time fairly, the court is going to allow that, but potentially. But if you have a time system capturing to the minute and you're not paying to the minute, that's something you're going to want to look at and maybe discuss with counsel. The court also said in Naranjo versus Spectrum Services that meal and rest break period pay is considered to be a wage that should be listed on wage statements and that can trigger waiting time penalties. So last year we talked about this a little bit more when the court was saying that you can't round meal period punches. And so if an employee is denied the opportunity to take their meal break, then they are entitled to a premium of 1 hour of additional pay at their regular rate of pay, which would include any a factor for bonus, for overtime, et cetera. Can't just be the flat hourly rate. And so that needs to be listed on the wage statement. And then it also needs to be paid at the time of final termination. So if you have potential meal period violations that are occurring that aren't being compensated for that premium hour, that's something that could give rise to a very large amount of liability, because the waiting time penalty is 30 days of wages. So that's something else to look at and consider in your policies this year. We had a big case coming out of the U.S. Supreme Court this year on the arbitration of PAGA claims. The court disagreed with the California Supreme Court when it was evaluating whether California's laws were in compliance with the Federal Arbitration Act. And the court decided that they were not. And so what this means ultimately is that as the law currently stands, an individual's PAGA claim, and I should go back and say what a PAGA claim is, I apologize. It's a Private Attorney General Act claim, a claim in which an individual employee can step into the shoes of the state and pursue penalties that the labor commissioner could have pursued if they had conducted an audit. And so 75% of any amounts have to be remitted to the state because it is a type of representative claim. But what the court said is that if you have an arbitration agreement, you can require the employee that signed that arbitration agreement to litigate their individual penalty claim in arbitration, which then deprives them of standing to go back and represent other employees in court. And so what this did is allowed us to add PAGA claims back into arbitration agreements. Now, I think it's probably pretty likely that we might see some legislation being put forward to amend the PAGA to address what the Supreme Court said. But for now, if you have arbitration agreements and you want to continue with those, you do have the option to amend them in order to include PAGA claims at this time. Okay, that's all I have on wage and hour. And just to recap, my takeaway for that section is a lot of the cases we're seeing are employees who are alleging that all of the minutes they're working are not captured. And that very quickly and easily turns into a class issue, because if it's a timekeeping system issue or a policy issue, then that means it applies to all employees, and we can address it on a class-wide basis. So this is something that you should look at and ask counsel about if you have questions regarding to whether all of your employees' time is being captured. I have a question about lunch periods for security guards. Security guards do have some options for flexibility if they have a collective bargaining agreement. We had a law passed a couple of years ago that addressed that. But security guards would follow if they don't fit within that exception, they're going to follow the rules for the rest of the employees under the wage orders, which means that generally, they get a 30-minute lunch period before the end of the 5th hour of work. But if the nature of their work, maybe they're at a remote location, they're the only one there, if the nature of their work is such that they cannot take a break where they're completely relieved of all duty, you do have the option to have the employees sign an on-duty meal period agreement. And that means that they agree that they are working during their meal period, but they do have the opportunity to eat and to take a lunch. And so that on-duty meal period waiver does have to be in writing and does have to be signed. It has to have some very specific language in it. So that would apply not just to security guards, but to other workers as well. And yes, shelters as well. I have a lot of clients that run residential facilities or care facilities, and they often utilize meal period waivers because they have to meet certain staffing ratios. And the employees have the opportunity to take a meal because they don't have active duty during that meal period, but they do have to be on the clock for the purposes of an emergency and to meet those staffing ratios. So a meal period waiver is a great way to address that if it's done correctly. Okay, any more questions on wage and hour? Okay, moving into discrimination and harassment. This year we had quite a few cases on discrimination and harassment. And again, this trend this year, specificity. So here we're going to see that in these discrimination cases. So this one was brought under the Equal Pay Act. It's sales director for Staples Inc. And she had her position eliminated through layoffs. And she was not happy, looked back through her pay, learned some things about it, and decided to bring a complaint in Superior Court because she was paid less than a male employee in the same position. So the summary judgment, which is the an motion we often file to attempt to resolve the case short of going to an actual trial. We could put in evidence and ask the judge to dismiss the case at that point if we're the defendant. So Staples succeeded at that stage, and the appellate court reversed because they didn't think that Staples had presented specific enough evidence about why this employee was not paid the same as her male counterpart. So when both employees started at Staples, they started with different starting salaries. And I believe it was a $22,000 differential between the two of them. So not insignificant. And Staples pointed to general practices about seniority and merit, the type of work these employees were performing, but nothing specific as to these two individuals. And then they were both promoted within a few months of one another. And the differential increased to about $45,000. So there was quite a difference here. And no one could testify, or no one did testify, as to what specifically about these two employees created that differential. Yes, we have policies that are appropriate that would give someone with more seniority or better performance a larger raise. But what specifically was the female employee doing that was not as good as what the male employee was doing? Or how had the tenure been affected from maybe a prior position, for example, that would cause her to be paid $45,000 less? And because of that lack of specific evidence, the court sent this back. And this case will end up resulting in a trial to determine the amount of damages. So when we're looking at, and we're going to get into pay scale changes that we've seen, again, the courts are demanding a very high level of specificity. And perhaps, some of this can result to the amount of time that passes. So by the time you get one of these cases in court, it could be 5, 6, 7, 8 years after the decision was made about the position. And so when they were hired, could have been 10 years ago. Did the employee who made the decision leave the company? Are they still there? Have they passed away? Does anyone even have this specific information anymore? It could be that this was a very legitimate decision, and there were reasons that would have stood up in court, but we no longer have those witnesses, and it just wasn't well documented. Or it could be that it really was discrimination against this female employee, and she really was suffering discrimination. And so regardless, the employer couldn't prove their position. And so that's what we need to do when we are giving raises and making distinctions between employees. There really does need to be specific information as to why those are being made so that you can prove it many years down the road. Because of course the plaintiff is still around, right? She's still there to put on her testimony. So the company goes through a fluctuation of employees. Now, this next case is another discrimination case relating to disability discrimination. So this particular employee was a substitute special ed aide for Victor Valley Union High School District. And she was working in a part-time role which didn't require any kind of medical testing. Then she applied for a full-time position, which used the same job description, but included a requirement for a physical exam because it was a full-time position. She failed the physical exam. This woman had had a stroke in the past, and over time her condition had actually improved, but she didn't pass her physical exam when she took it. And she was denied the position, and then also terminated from the part-time position she had been performing. And the question that the court we're looking at here was, could she run after students? And she could not. Was that an essential function of her job that would allow her to succeed on her disability claim? Or could she not perform an essential function so she didn't need to be selected for that position? And we talk a lot about what are essential functions. How do we determine what they are? One large factor that we always point to in disability discrimination cases is what's the job description, right? Do you have a job description that lists what's really essential for this position, and what are just tangential job duties that could maybe be performed by someone else if needed? So maybe you have, I like this example, you have a receptionist. She sits at the front office and she greets people as they come through the door, and she answers phone calls. I think those are her essential functions, right? But she also does some filing on the side. How essential is that? Is that necessary to the operation of the business, or could that be performed by any job duty if she had hand surgery, for example? And so the job description is one thing we look at, but we also look at the actual tasks that are being performed. And here, this job description was the same for the part-time and the full-time position. So why did the full-time position require running and the part-time position didn't? She had used a bunch of other methods for working with the students, including behavior de-escalation techniques and relying on a security guard to assist when a student eloped. And so the question was, why couldn't she consider doing that? And then also she pointed to the fact that there were other sites that had open positions where running after students didn't ever occur because of the nature of the students at those sites. So could she have been placed in one of those sites? And so these are the takeaways from this, is that we really have to look at what our essential functions are, should update our job positions, job descriptions to make sure that they're actually reflecting what various people are doing, and then evaluate whether adaptations could be made to those. So there could have been different job descriptions between the full-time and part-time position. Perhaps they could accommodate someone just for a part-time period, but for a full-time, they didn't have enough security staff, for example. It depends. So that's something to be considered as you're moving forward this year, is do we have those specifics? And maybe even with the job descriptions being different, there could be a pay differential, which could be relevant, right? So all of those things to consider as we move forward. This next case is discrimination case based on age, race, and gender. So this employee is not quite exactly sure why she was discriminated against, but she's certain it happened. So she was working as a physician and surgeon for a contracted company with this hospital, or actually with the state personnel board for the hospital. And I said that backward, for the Department of Corrections and Rehabilitation. She was working as a physician and a surgeon, but not directly, through a contractor. And so she, over the course of time, applied for several positions with the Department of Corrections and Rehab directly. She wanted to be a direct state employee. And multiple times she was not interviewed or hired. And she was actually removed from her position as an independent contractor as well, because her credentialing was revoked by the department. And so she brought a discrimination claim because other colleagues were selected for interview and were ultimately hired who were performing the same job she was. And again, the business ran into trouble here. The Department of Corrections ran into trouble because they didn't have specific evidence supporting their legitimate and non-discriminatory reasons for adverse actions. They had a few specific reasons. She was written up once, for example, for not responding to a call because she was in the lunchroom and didn't hear it. And there was, I think, a couple complaints that she was abrasive and not getting along with others. But then there was conflicting testimony that she did a good job as a contracted physician, and that she was performing her job well. So the department failed to introduce specific evidence of why for each job she wasn't selected for interview while others were, and for each job she wasn't selected for hire. Then they also failed to introduce specific enough evidence as to why her credentialing was revoked. And so this was sent back to the court to proceed with a trial. So again, the reason why they didn't have this evidence is either because A, it didn't exist, and the decision was discriminatory, which we'd want to go back and do more training with supervisors. We'd want to look at our hiring processes and determine why a discriminatory motive was affecting our hiring process. Or B, it wasn't well documented, or there wasn't an employee who could testify to it any longer. And if that employee isn't there, it needs to be documented so that someone else can testify to it. And we had two suitable seating cases. Suitable seating being an employee's right to use a seat either while they are performing their job tasks or in downtime while they're waiting for a job task. And we haven't seen a suitable seating case that made it up to the appellate court in quite some time. So I thought I would just mention this here. But we have to remember that there are two situations in which employees get to have seating. The employee here at Ralph's grocery store was looking for seating in between customers at the checkout stand. And Ralph's introduced evidence that there wasn't any downtime that would require seating, because when their checkers weren't checking people out actively, they were supposed to be restocking shelves. And so there wasn't downtime for sitting. Whereas the next case that we thought from AutoZone, this employee was at that front counter they have there, if you've ever been into an AutoZone, and she did have downtime. She wasn't supposed to be restocking parts. She was supposed to be continuously staying up at the front. And in between customers, she did have an opportunity to sit down and was entitled to suitable seating for that. In this case, the two chairs were outside the manager's office, not up front right by the counter where it would be obvious to an employee that they were for their use. And no one specifically told her that she was allowed to use those two chairs. So AutoZone pointed to these two chairs as suitable seating, and the plaintiff was able to prevail on that because she proved that AutoZone had not made the suitable seating available to her. So be clear in what you're telling your employees with regard to suitable seating and what their job duties are in between customers. But this would apply in, it's in nearly every wage order. So it would apply in any industry in which seating would be appropriate. Moving on to remote work locations. I'm not sure what category of case this goes into best, but I stuck it in here. This employee brought a discrimination claim, but that's not really the takeaway most important to us here. She alleged some pregnancy discrimination, and she said that she wasn't reinstated to her position after her pregnancy leave. She had originally worked in Orange County at the corporate office, and during COVID, she began working remotely from Los Angeles County. And she filed her case in Los Angeles County, and the company filed a motion to move the case back to Orange County. And the employee prevailed, and her case was allowed to proceed in her home county. And the court said that's because she worked there, the alleged discriminatory action happened there, and she would have been reinstated there if there hadn't been discrimination. And so what this just raises for us is the importance of knowing where your employees are. So it can affect what venue your cases are in. It can also affect what laws apply to your employees. Minimum wage laws are different all over the state in different counties and cities. There are different poster requirements. There are different, like San Francisco, for example, you have all sorts of retail workers' bill of rights, paid sick leave, various things. So it's important that if you have remote workers, that you require them to tell you where they are working. And you can even consider perhaps prohibiting employees from working in another state or country for more than 30 days without your written consent. Because, for example, some employers simply don't want to take on the liability for an employee working for a long enough period in time in another venue to trigger their laws. So, for example, if you have an employee who goes to live in the EU for 6 months, EU law could potentially apply to them, which is extremely cumbersome. So you want to know and make a conscious decision about whether or not you want to have employees working in these various jurisdictions. So it's important to know that and get that information. And if you have employees working remotely, to have a remote work policy in place. We saw a new addition to the Fair Employment and Housing Act to add reproductive health decision-making as a protected category. It includes decisions to use or access a particular drug, device, product, or medical service for reproductive health. And you can't seek disclosure of this information from your employees. It doesn't affect too much of our policies because most employers were not asking about contraceptive health anyway, but there will be some changes to healthcare plans beginning in January of next year that you may be receiving information about, and that may have a little bit more of an impact in terms of what healthcare plans are being offered. Also, the last thing we have in this category is that the Department of Fair Employment and Housing, the DFEH, has changed its name. It is now the California Civil Rights Department. That's their new logo. And the Fair Employment and Housing Council is now the Civil Rights Council. So we see these abbreviations changing. If you go to their websites now, you'll see their new logos and their new abbreviations. I can tell you it's going to be really hard for me to adjust to this change. But that's okay, I'm gonna try. Okay, that's it for discrimination and harassment. Does anyone have any questions about that section before we move on? Okay, moving right along to whistleblower retaliation then. Well, whistleblowers and retaliation. This is a case involving the Regents of the University of California, so a UC employee named Shear. It was a physician that sued for whistleblower retaliation under various labor code sections, government code sections, and health and safety code sections. And this employee was terminated. And the issue that kind of floated to the top and took notice of and ended up at the Court of Appeal was that this employee had been given a performance evaluation just a few months before the termination. And the employer said that the employee was terminated for various performance-related reasons. And the court said the fact that this performance eval was a good performance eval, average performance eval with no noted deficiencies, created a triable issue of fact, meaning this case could go to trial. And we can see what the jury believes with regard to those reasons. But this case could have been resolved potentially at a much earlier stage had the performance evaluation matched the reasons that the employer gave later. So earlier we talked about the need for specific reasons. And they had a witness that gave specific reasons in this case. Unfortunately, their documentation didn't match that. And we see this quite a lot, actually. There's several things you can do about it. One, always training. Train employers to, sorry, not employers. I just was making sure that wasn't a message saying that my webinar lost sound or something. So one is train your supervisors. They should know that their performance evaluations are not just something they have to check off, but something that could really be important down the road. This particular performance evaluation was a traditional checkbox style. So satisfactory, satisfactory, satisfactory. There was a box for comments along the bottom. Nothing was written in, supervisor's signature, right? So great performer, probably not, but no indication of poor performance, and then no comments. So supervisors need to be taught to fill those in correctly. They need to be taught the importance of that. And they need to also, I think the next thing is, do you want to use the checkbox performance eval, or do you want a more collaborative process where more detail is likely to be given? And so I think that that's something that you want to consider when you're thinking about how do we get that specificity, and then how does that specificity match what's actually going on in the workplace and what our supervisor is actually going to say. Also, if a supervisor is having enough problems with an employee that within a few months they're going to want to fire them, there should probably be a dialogue between management and human resources and the supervisor about a process that needs to be put in place to either improve performance or terminate this employee at the time that that performance evaluation is being done. So this should have been part of an ongoing process rather than occurring just right before a termination. This would be different if, say, we discovered that this employee had stolen $100,000, right? Something later discovered doesn't need to be reflected on the performance eval. Can be a great performer and still fired for severe misconduct. But that wasn't the reason given in this particular case. Okay, that's the only one I had for retaliation, actually. Are there any questions on that? Hold on, I do have, question. I have a question on meal break waivers that I think I missed from earlier. So let me just jump to that real quick. Employees answer a question when they clock out of the time system. Meal break waiver: for a shift where I work 5 or more hours, but 6 or less hours, do I waive my meal break? They answer yes or no, depending on what's applicable. Would that satisfy the waiver for shifts where they work between 5 and 6 hours? Yes, potentially it would. The requirement for shifts that are less than 6 hours is that the employee has the option to waive their meal period. It's not required by the wage hours to be in writing, but in every case I've ever worked on, the employee says they didn't want to waive that meal break once litigation arises. And so how do you prove that they did at the time? And that's through a written waiver, right? So having them sign every day, I think would satisfy that purpose. I think it does depend on how the system is set up. It has to allow them to move forward even if they click no, for example. I do have employers that use a system where if an employee misses a meal break, that's flagged, and then they need to explain why. Did they choose to come back early? Did they choose to leave late for their lunch? Or were they required by their job duties or supervisor to do that? And then they only pay meal period premiums for those where it was actually job necessity to stay or to not work that full lunch period. And so you can do all sorts of different waiver systems in writing on the computer, etc. But a meal break waiver for the meal period when someone's worked over 6 hours is required to be in writing, and it has to be possible to revoke it. So you have to have the correct language on there, and that would be something you would put in the file versus a day-to-day waiver for the one that's not required to be in writing. Okay, a household employee such as a nanny, does that apply as well? And I think we're talking about meal breaks and meal break waivers. The meal and rest period requirements for household employees are slightly different than non-household employees. And I don't have time to go into that in specific today. There's two things that apply, one the wage order and one the domestic worker bill of rights. So if you want to shoot me an email, I can get back to you on that offline. Another question is about investigations for violence. And an employee was let go because he was determined through the investigation to have committed violence in the workplace. Can that employee claim retaliation? So in a retaliation case, what the employee has to prove at the outset of their case that there are some facts that give rise to that retaliation occurred. Essentially, that's it in a nutshell. It's much more specific than that. The employer then has to prove that the employee was terminated for a non-retaliatory reason, and that there wasn't a nexus between the complaint and the termination. So in that case, the employee who complained was found to have committed violence. But I imagine that the employee's complaint wasn't about his own violence. So that right there would break the nexus between the complaint and the violence. But you're going to want to have very good evidence in a case like this that there actually was violence, so that you can prove that the reasons that you're putting forward for his termination were legitimate and unrelated to any complaint, and so unrelated to any protected activity. So if you can establish that, if you pulled up security footage and you saw Bob punch someone, that's going to be a non-retaliatory reason for a termination. And the fact that he complained doesn't protect him for termination for his own misconduct. Okay, terms and scope of employment. So this is a representation case. So this employee was told that the company was planning an aggressive expansion, and they needed a manager who was going to be with them for years to come to build up and lead teams of project managers in the San Francisco Bay Area. This employee quit their job in Washington, moved all the way to San Francisco, took this job. He was an at-will employee. He didn't have an employment contract with a fixed term. 5 months after starting, he was terminated, and the entire sales operation was moved to Bulgaria. The employee brought a claim under the labor code that he had taken the job based on this misrepresentation and in reliance on it, which gives rise to some different types of damages. And the employer said, well, no, he couldn't have reasonably relied on this longevity of the position because it was an at-will position. He could be terminated at any time for any reason. And the court said no. At-will does not overcome these more specific promises that have been made about this expansion. And of course, so this case got sent back for a trial again, and the jury can decide who they believe, but ultimately the at-will did not allow the employer to get rid of this case early on. Was the employee reasonable? Were these statements actually made? Does the jury believe him? That's up to the jury. But the at-will is not enough to defeat this claim. The next case is ABC test for subcontractors workers. We don't have changes to the dynamics test this year. We don't have changes to the ABC test for determining whether someone's an independent contractor, but we do have this case. There were quite a few cases actually, but this is the one I think most relevant. So this is Ruoso's Construction, who had three individuals working underneath it. It called them subcontractors. And then under those three licensed individuals were three or several unlicensed flooring installers. The flooring installers said that they should have been classified as employees of Ruosos. Rosa said, no, you have to first prove that you were directly employed by us, that we interviewed, hired you, etc. You weren't our employees. You were employees. If you were employees at all, you were employees of these subcontractors. And the court said, no, there's no threshold test for who hired you. We jump directly into the three ABC factors. And we say, A, how much control was exerted over these individuals, these unlicensed flooring installers by Ruoso. B, what was the nature of this relationship? What were they performing the same type of work as Ruosos? And C, were they actually performing this work for others? And so we can ignore those three intermediary level supervisors or independent contractors and just make a decision about whether these individuals were employed by Ruosos under the ABC test. And so this is something that could have been avoided in a variety of ways. Hindsight's 2020. First of all, there were no written agreements in this case. There are exemptions for the ABC test for construction workers and subcontractors, which would have applied in this case had there been written contracts. Second, if they'd had written contracts for indemnity from their subs for not properly hiring their workers, that would have been super helpful. And also, Ruosos potentially could have, or maybe did, who knows, we didn't see it in this case, had rules and restrictions for their workers about how much control they were exerting over the workers of the subs, because this comes into play not only for wage and hour cases, but also for potential liability for injuries on the job to either workers or others that are on the work site. So Ruosos needs to make a decision about how much control it wants to exert over others on the work site and the safety of those individuals. Okay, this case we can do real quick because we're getting short on time. The court said that you do not have to compensate workers for pre-employment drug testing costs or pre-employment drug testing time spent. So this worker said, I was hired, I want to be paid for that time for my pre-employment drug testing. And the court said, no, you were not an employee at the time, you were just an applicant, no obligation to pay for that. Now, a lot of employers do, but it's not required under the labor code. Okay, moving on to leaves of absence. Do we have any other questions about employment terms? Okay, leaves of absence. Bereavement leave was passed this year after, 10 years. We saw it proposed over and over again. It was passed. So beginning on January 1st of this year, employers have to provide up to 5 days of bereavement leave following the death of a family member. And that's unpaid time. Unless you already have an existing policy that pays for some bereavement leave, then you can't go ahead and revoke that, but just because this law passed. There's a twist for state employees who already had bereavement leave. They now have to receive 3 paid days and 2 unpaid days. This applies to all employers with 5 or more employees and to public entities. To be eligible for bereavement leave, employees have to have been employed for at least 30 days prior to the leave. There's an exception for those of you with collective bargaining agreements that have bereavement provisions. The leave has to be completed within 3 months of the death but it doesn't have to be consecutive. So an employee can take one day off immediately following the death due to grief, and then they can take another day off in a month for the actual funeral service. And the employee can apply other paid leave to their bereavement leave. So if you didn't offer bereavement leave and now you're going to have to, they can use their sick time or they can use their vacation time to give them compensation for what would otherwise be unpaid. So if you have employee handbooks, this needs to be updated. Under the California Family Rights Act, which provides 12 weeks of leave, unpaid for those of you with 5 or more employees, and paid sick leave, which applies to all employees, that can now be taken for a designated person. So say I have a boyfriend, I want him to be my designated person. He goes in for major surgery. I can request that I be allowed to take California Family Rights Act leave to care for his serious health condition for that 12 weeks. Now, if I have 8 boyfriends over the course of a year, I don't get to take 12 weeks off for each of them. You can require an employee to choose only one person per 12-month period. This can also be maybe an elderly neighbor that someone has taken responsibility for. It could be an aunt, someone that's not necessarily within that family designation, which if I can remember off the top of my head, children, stepchildren, parents, parents-in-law, and grandparents and spouses. If it's not within that family group, they can use that designated person category to care for that individual. COVID supplemental paid sick leave expired at the end of last year. However, there are some counties in California that are still requiring it through the end of the state of emergency, which is scheduled to end on February 28th. Just a heads up. Okay, that's it for leaves of absence this year. Any questions? No, great. Okay. More workplace policies. Pay scales. Mentioned this earlier in the presentation when we were talking about discrimination and being able to prove the difference in pay rates between a female and a male employee under the Fair Pay Act. We have pay scale expansion that kind of goes in that vein of being transparent with our pay and having very concrete reasons, specific reasons for it. So this year, beginning January 1st, all employers must provide pay scale information to current employees for the position in which the employee is currently employed upon request. I should have included that upon request part on this slide. You don't just have to distribute it. But if someone asks for it, they can get the pay scale information for their position. Previously, last year, that was you had to provide it only to applicants, but now current employees can ask. What is a pay scale, you ask? A pay scale is the salary or hourly wage range that the employer reasonably expects to pay for that position. So if you are posting a job for an entry-level administrative assistant, you do not have to post the wage range for an experienced executive assistant or administrative assistant, because that's not what you're reasonably expecting to pay. Now, if you get an application from a very experienced administrative assistant, yes, you can go ahead and pay them what they're worth, right? What your pay scale is essentially for an experienced administrative assistant. But you have to be clear when you make that posting, what job is it? What are you looking for? And what are you reasonably expecting to pay for what you've actually posted? The same potentially applies for your current employees. And when we go talking about job descriptions, for example, this is another reason to take a look at them. Am I using the same job description for a huge range of employees who are doing actually quite a bit of different tasks or not? And then you have to maintain pay scale records for all employees for the duration of their employment plus 3 additional years. So this is an increase in maintenance requirements. And if you have that's applicable, what I just talked about, to all employers. If you have 15 or more employees, when you make a job posting, you have to post the pay scale. And that would include even if you're posting through like a third-party site. Pay data reporting has increased its requirements. Employers with 100 or more employees have to provide pay data reporting to the DFEH. Employers with 100 or more employees hired through labor contractors, such as staffing agencies, must also submit a separate report. And reports have to now include some additional information. And beginning this year, and then each year thereafter, they're going to be due the second Wednesday in May. Marijuana use continues to expand in California. I don't know whether use expanded, but the laws are expanding to allow it. There is an amendment to the Fair Employment and Housing Act to prevent discrimination against employees or applicants based on cannabis use off the job and away from the workplace. Of course, you can still discipline employees for being intoxicated at work. Totally okay. You can prohibit that, and you can prohibit them from bringing substances onto your workplace. But then we also have this little twist, which might alter some drug testing. Drug screening tests that found the person to have non-psychoactive cannabis metabolites in hair, blood, urine, or other bodily fluids cannot be used to discriminate against an employee. You could test for THC. So you want to be certain that the drug testing you're using is fitting within these new requirements. And like I said, you can still have prohibitions against being impaired or possessing cannabis at work. And also, if you have requirements imposed by federal law or regulation, such as in the building and construction trades, DOT, et cetera, or any position requiring federal background investigations, there's exemptions for that. You still have to comply with all federal law, and there's an exception. It also doesn't preempt state law requiring testing for controlled substances. So if you are in a position that requires specific state testing, you follow the state law, there's an exception. There's a new addition for retaliation related to emergency conditions. If an employee fails to report to work or leaves a workplace because of an unsafe emergency condition, either at home or at work, they can't be retaliated against for that. For example, wildfire, active shooter situations, et cetera. But we have exceptions, of course, for first responders, healthcare workers, those working at licensed residential care facilities, and some other safety sensitive positions. And you can't prohibit your employees from using their mobile devices in an emergency to seek assistance, assess safety, or communicate with someone to tell them they are safe. And this is what an emergency condition is. It's a disaster or extreme peril to the safety of persons or property at the workplace or work site, or an order to evacuate a workplace or the worker's home or the school of a worker's child. It does not include a health pandemic. There's now a requirement to provide access to those with eligible medical conditions to use employee restrooms that are readily accessible to the public. Doesn't require any modifications, but it does require access if someone requests and has a condition. We've seen some changes to COVID exposure notices. Some of the requirement to provide them has been extended through January of next year. They can now be posted in the workplace or on an intranet site, including the information that's listed here. It has to be posted within 1 business day from you receiving notice of an exposure. It has to be kept up for a minimum of 15 days. And you have to keep a log of your postings. The close contact requirement or definition changed in the fall of last year. The infectious period is defined as 2 days before symptoms through 10 days after symptoms first appeared. Those testing negative on or after day 5 are no longer considered to be in their infectious period. And a close contact is defined as someone sharing the same indoor airspace for a cumulative 15 minutes over a 24-hour period. If you are curious about what indoor airspace is that's shared, the Department of Health has a definition of that depending on square footage. COVID prevention doesn't need to have its own independent prevention plan anymore. It can be now included in your injury and illness prevention plan and should be included in your injury and illness prevention plan. And it requires the same requirements for your other aspects of that, which is identifying, assessing, and responding to COVID-19 hazards and training on them. And you still must immediately exclude all COVID positive cases from your workplace and require masks until the 10-day infectious period has passed. One last reminder, and then we'll wrap up here. Employers with at least 5 California employees had to register for the CalSavers retirement program if they didn't offer a separate retirement plan to their employees. So if you didn't do that, now is the time. That deadline was June 30th of last year. But if you do not offer your workers a retirement program and you have at least 5 of them, you need to register for the CalSavers program so they can utilize that state retirement system. One more section, I'm running behind. There was a lot this year. Employee data privacy. We used to have an exemption for employment from the California Consumer Privacy Act. That has expired. So now, if you are covered by the Consumer Privacy Act, here's the 3 requirements to be a covered business. You have to take these following steps with your employees. You have to give a disclosure to applicants and employees about what personal information is being collected, shared, or disclosed about them. Allow for a process to correct the inaccurate personal information. Delete any specific personal information with certain exceptions. They can opt out of you sharing their personal information with vendors. Most employers are not sharing personal information to begin with, but you can opt out of that. You have to restrict the use and disclosure of sensitive personal information, and you can't retaliate against anyone for exercising their rights. So in a nutshell, 4 new requirements: provide updated privacy notices, respond to data rights requests, limit the use and disclosure of personal information, and obtain contractual commitments from your third parties receiving information that they're not going to be sharing your employees' information. And so, yes, that's if you are covered by the consumer. Only if you're covered by the California Consumer Privacy Act do those now apply to you in the scope of your applicants and employees. Okay, I have a few minutes to answer questions if anyone has them. Also, you can feel free to give me a call or shoot me an email. I'm currently behind on my emails, but I'll try and get to them over the weekend and get back to you on Monday with any questions that you have arising from the presentation. Hopefully this was helpful for you and gives you an idea of some things that you can focus on this year to increase your compliance with California employment law and to see kind of where the trends are taking us as we move into the next year. I am not seeing any questions, so I am going to go ahead and sign off and stop this recording. Thank you so much for attending. I do have questions. It didn't scroll down. Hold on one second. All right. So I am still going to go ahead and stop my recording, but then I'll go ahead and answer your questions. So one second.